Good morning. My name is John McGinnis, and I'm a professor at Northwestern Law School, and I'm delighted to welcome you to our panel on originalism and its discontents. The very title of this panel may seem a little paradoxical because originalism, which has been a central project of the Federalist Society since I joined it 3 decades ago, has never been at a higher point in its certainly modern history. The court has at least a plurality of originalists and maybe now a majority of originalists. I thought the most interesting part of Justice Alito's speech to the National Convention was his claim that originalism would be the parole of the court going forward. And in academics, originalism, which when I was a law student was not even mentioned in constitutional law, has become an extremely important theory and indeed a completely dominant theory on the right of the political spectrum. And it's a rich theory. It's become fractal in nature. There are really strong intramural debates about the nature of originalism, and that's a mark of a very strong theory that has attracted inquiry and substantial debate. So at that time, one might see originalism as just triumphant, but at the same time, we've noticed that there's some discontent with originalism, particularly from the younger generation of scholars, often who are identified with conservatives. It's not, or libertarians. It's not surprising that there's discontent on the left with originalism. There always has been. Now, some might just put that down to the ritual slaying of elders that is a mark of academic life. But I think it really captures also some of the fractures on the right of the political spectrum, fractures that have become all too apparent in the years of the latest president. But however much it is coming from the effects of politics, I think it is really very welcome to the debate on originalism for 3 reasons. First, it enlivens the debate. So the debate between originalism and living constitutional on the left is a little predictable. This is not predictable. There's a danger that the intramural discussion of originalism, as rich as it is, and I'm certainly a participant in that debate, can become scholastic, and this can enliven it. Secondly, the other advantage is that there may be elements of these discontents that need to be integrated into originalism. And finally, while I am an originalist, and I'm very proud that originalism has now attained this level of importance in constitutional theory, no one who looks at the history of the Supreme Court should be confident that originalism is the final word from the Supreme Court. The Supreme Court and the culture changes, and we may be witnessing in this discontent the beginnings of some new theory. After all, when I was a law student, it was unimaginable that originalism would have the purchase that it does today. So we may be getting a glimpse into the future. So I'm going to introduce our panels as they speak. And we have a very, I think, rich and different people with different points, different kinds of points of discontent. And at the end, we'll have some defender of originalism to try to put this in the perspective of a paid-up originalist. So with that, let me introduce, first of all, Jesse Merriam, who's a professor of government at Patrick Henry College. We look forward to his remarks. I should say one other point that I've been asked to note is that there'll be questions from the audience, and that after our remarks and some interchange, and that the audience should use the Zoom raise hand function, or if their phone, they should press star 9. But with that, Professor Merriam, we look forward to your remarks.
Really appreciate that, Professor McGinnis, and I am honored to be here. I admire all the panelists, and I'm really looking forward to this conversation. So I'd like to begin by explaining the nature of my discontentment. And I want to explain this in some detail because it's probably a little bit different from some of the other panelists and what they may say about originalism and why they are dissatisfied with it. There is certainly an emerging conservative or right-oriented anti or non-originalist movement. I think you could safely put Professor Adrian Vermeule of Harvard Law there. Perhaps Josh Hammer, Senator Hawley has suggested that he is in this camp. And I have been a critic of originalism, but it's not because I'm an anti or non-originalist. If I were a judge, I'd probably be an originalist. If I were a law professor, I'd probably be an originalist. But I'm a political scientist who studies judicial politics and social movements. And my interest in particular, and this is coming from Stephen Tellis, who is one of my advisors at Hopkins, is the conservative legal movement, or the legal conservative movement, and its use of courts to promote its agenda. And my interest in originalism comes only from my interest in legal conservatism. If it were not related to legal conservatism, I probably would not be writing about originalism. So why is there a relationship between writing about the legal conservative movement and originalism? Well, it comes partly from the field of research that has followed Stephen Tellis's book in 2008, dealing with the successes of legal conservatism. So a good example of this is Amanda Hollis-Brusky's book, Ideas with Consequences, which looks at the Federalist Society and originalism as the principal bases for saying that there has been, in her words, a conservative counter-revolution. And my work in various articles has tried to challenge that narrative or complicate the idea that there has been a conservative counter-revolution. If you look at the case law, you'll see that in many areas that had been central to legal conservatism in the 1950s, 60s, 70s, and 80s, there has been a dramatic leftward shift despite the ascendance of originalism over that time, despite the fact that Republicans have controlled the Supreme Court now for over 50 years, despite the fact that the Supreme Court has, with 16 of the last 20 justices, have been nominated by Republican presidents. So despite all of that evidence of a rising conservative movement, we see that there has been quite a bit of failure. So how does that lead me to originalism? Well, if you look at these works, and there are roughly 10 books on the subject, you'll find that one of the principal bases for saying that there has been a successful conservative counter-revolution is the ascendance of originalism. So it's often pointed out that Atlantic Kagan in her confirmation hearings said we're all originalists now. That obviously would be unfathomable. At the time of when Justice Scalia was nominated or when Robert Bork was nominated. At that time, you could be borked, right, for being an originalist. But now we have Atlantic Kagan saying we're all originalists. Brett Kavanaugh, Neil Gorsuch could go into extensive discussions of their originalism without the fear of being borked. So this is evidence of a successful conservative counter-revolution. Well, one of the problems I have with that, and I guess this is what makes me discontent with originalism, is that we don't often evaluate socio-legal movements based on the mode of interpretation that it's associated with. So we don't say that the NAACP or the ACLU or Lambda has been successful because of the prevalence of some mode of legal interpretation. We say because desegregation or abortion or same-sex marriage has been advanced through the courts that they've been successful. But for some reason, when judicial politics scholars write about legal conservatism, all of a sudden, we're not concerned with the actual agenda being achieved in terms of decisional outcomes or social change. We're concerned only with a mode of interpretation in terms of how many times it appears in law review articles or in judicial opinions. So that, to me, is puzzling. Why is there an asymmetry between how we talk about legal liberalism in terms of decisional outcomes and actual social change, and then in contrast, how we talk about legal conservatism simply in terms of the number of law review articles or the mainstreaming of originalism? The second problem I have with using originalism as a metric for evaluating the successes of this conservative counter-revolution is the idea that originalism is a monolithic theory. So if you simply point to originalism as your basis for saying there's been a conservative counter-revolution, but you ignore how much originalism has changed over the years, from what it was in the 1970s and 80s, one based on historically rooted intentions, to one that is now based on more general abstractions in which the normative content can be filled in with changing understandings of social values. What you see is that originalism has moved away from something that was much more rooted in American traditions to one that can adapt to contemporary changes, right? New social understandings. That looks a lot more like legal liberalism. So if, in other words, originalism is your basis for saying that there's been a conservative counter-revolution, but you ignore that originalism has become more adaptable to legal liberalism, your basis then for saying that legal conservatism has been successful is that it looks more like legal liberalism. And that is a big concern I have in terms of saying, look, there's been a conservative counter-revolution. And that may be partly why, when we have 16 of 20 Supreme Court justices appointed by Republicans, we still don't see the rightward shifts that one would expect. It may be that originalism is part of the explanation. And then the third issue, and I will close with this is related to that second point. The second point, if you recall, is that originalism has changed in theory and how it operates. But it's also changed in terms of the ideological and legal agenda that's been pursued under the banner. So if you look at the law review articles, the opinions in the 1970s and 80s that had an originalist salience, it mostly had to do with social issues. But if you look at the way that originalism operates now, it's much more associated with what you might say is a libertarian or even a progressive agenda. So there's been a huge shift in how we think about which issues are associated with originalism. And again, this has to do with my questioning whether or not you can simply say that because originalism has been ascendant, that must mean that there has been a conservative counter-revolution. If its form and its agenda is much more accommodating of a progressive set of values and way of looking at law, I think that it is very problematic to say that simply because this has been a prominent theory over the past 2 decades, that we can say that legal conservatism has succeeded. And as I just mentioned, I do think you can perhaps question whether or not it's partly responsible for some of the failures of legal conservatism, in that it has taken so many resources to try to convince people of why originalism is correct, and it has taken away attention from the fact that legal conservatism has not achieved many of its foundational goals when it set out to advance its agenda in the 1950s, 60s, and 70s. And with that, I'll move on to the next speaker.
Well, thank you very much, Professor Merriam. Now we're going to Professor Josh Kleinfeld, who's a professor at Northwestern Law School and my colleague. Professor Kleinfeld.
Thank you. Thanks for having me. And I want to say at the opening, thanks to John and Randy and to the Federalist Society for holding this panel. There have been rumblings of discontent about originalism within the Federalist Society for years. We all know in 2021 what you're supposed to do with internal dissent. You're supposed to suppress it and squelch it and defeat it. The Federalist Society is the only organization I know that does the opposite and gives it a hearing in public and discusses it. So I just want to say thank you for that. My overarching claim is that originalism has become detached from its roots in judicial restraint and majoritarian democracy, and that conservative approaches to the Constitution should return to those roots, those majoritarian and judicially restrained roots. So let me start by saying a word about those roots, those foundations. Originalism, at its origin points, was grounded in two aspirations. One was the conception of a conception of constitutional self-government in which major policy issues ought to belong to the elected branches. There was alarm over the constitutional expansiveness and assertiveness of the Warren and Burger courts, and an emphasis, a concomitant emphasis, on the legitimate role of the elected branches, especially Congress or state legislatures, in making contested judgments about values. The emphasis there on democratic power and judicial restraint was partly based on legitimacy conceptions. The idea was that in a country that is constitutionally grounded in self-government, the big policy issues of the day, not just the big, just most of the policy issues of the day ought to be made through democratic processes and not subject to judicial override. There was a sense that judicial review ought to be an exceptional power for extraordinary situations, not a routine one. It shouldn't be the case that every major issue of politics and policy that arises in the United States ultimately is transfigured, or maybe the better word is metastasizes into a constitutional question for judicial resolution. So those are legitimacy concerns. There was also, I think, correctly, a sort of prudential substantive prescience, an understanding that the long-term welfare of conservative values lies with the majorities of the American public, that the conservatism's interest is majoritarian in the long term, that many of the values of the left are elite values, which will have their home in academic settings and will not conquer the hearts and minds of American voters. And so there was a sort of conservative majoritarianism that Burke talked about. He talked about the French revolutionaries' academic qualities and character as something led by an elite vanguard, and has been observed of the far left ever since, and continues to be true of the far left. All of this gave conservatism common ground with James Bradley Thayers' theory. James Bradley Thayer was a 19th century constitutional theorist, arguably the origin point for constitutional theory as an academic discipline. And it was his view that Congress should strike down, the court should strike down an act of Congress only if that act so clearly violates the Constitution that no rational person could think otherwise. The standard for striking down an act of Congress was that it be plainly irrational in light of the Constitution, and no less. And so it was a highly deferential, democracy-oriented conception of judicial review and judicial power. Many of the early originalists, including Scalia and Bork and others, made common cause with that ideal. Well, what has happened since is a drifting away from those early ideals. So I'm a critic of what originalism has become, how it's developed, but it's not because I reject those early aspirations or ideals. To the contrary, my claim is that originalism in its current iteration has become detached from that orientation to majoritarian democracy and judicial self-restraint. Let me pull out just a few examples relatively briefly, as I know time is limited, but I think they not only prove the point, but also enrich it. Here is a recent a recent article by Steve Calabresi. He says, quote, "I conclude that no person can be both an originalist and a Thayerian. Professor Thayer's position was enormously influential, accepted as scripture by Justice Holmes, Frankfurter, Rehnquist, and White. His views show up as well in the writings of Judge Bork and Justice Scalia, both of whom often confuse originalism with the analytically distinct concept of Thayerian self-restraint. But I doubt that Professor Thayer understood how much harm his writing would do." And Professor Calabresi goes on after that to basically to list a long series of cases in which what he would like is more judges striking down statutes, more aggressive acts of judicial intervention. What he so objects to in Thayer is not enough striking down the acts of the elected branches by the judiciary. Professor Calabresi wants judges to be aggressive about judicial review. A recent set of interviews with Supreme Court justices found them, including the originalists, laughing, mocking the old adages of Felix Frankfurter, the orientation to judicial minimalism and judicial restraint that Frankfurter represented. Richard Posner and Lee Epstein, Richard Posner as a judge and Lee Epstein as an empirical social scientist, tracked empirically the idea of judicial restraint and found that it reached an apex, a sort of zenith, and it's been descending ever since. And it has not been preserved by judges appointed by Republican presidents. I've found that judicial restraint has become a dirty word among many Federalist Society associated professors and students who think that it means betraying the Constitution. For me, a seminal moment in this regard, and I say this with utmost respect for Randy, was the Obamacare litigation. My view of this litigation would be disputed by Randy and many others here, but it was seminal for me in 2012 and many of my younger kind of conservative friends. We looked at that and we saw a constitution that says nothing about national health care. It just doesn't refer to it, or insurance markets. And we saw insurance markets that are plainly interstate commerce. And we thought this should be unproblematic as a matter of constitutional law. Difficult policy choices to be sure, but unproblematic as a matter of constitutional law. And then what happened? Once the conservative side lost the political battle, a professor came up with a innovative, unexpected, originalist argument against the statute, and almost got the statute overturned by the court, exercising a sort of veto over the actions of the Democratic branches in what to me was a kind of landmark demonstration of judicial supremacy. All that just strikes me and struck my conservative-leaning friends as just a daft way to run a government. The idea that you have a major public dispute finally resolved by the elected branches, and then some academic comes up with an argument, creates on the basis of original meaning, and creates constitutional litigation that can overturn the legislation. Just, it was delegitimating to the originalist project. Okay, I'm at the end of my time. Let me just say a few words about where we go from here in my view. One possibility is to return to that old-time originalism. I'm wary of rejecting the term originalism and the values of originalism when that term and those values have acquired so much political capital and so many adherents within the judiciary. But we could aim for internal reform, try to recapture a form of originalism that is majoritarian in its orientation and grounded in judicial restraint. Another possibility is to explore new interpretive possibilities. One that intrigues me, I'm not sure it's workable, but I think it's very interesting, is a sort of strict constitutional textualism. A way of developing theoretically the idea that, hey, the Constitution doesn't say abortion, so it doesn't speak to abortion. The Constitution doesn't say healthcare, so it doesn't speak to healthcare. If the Constitution says speedy and public trial, and that gives judges a certain amount of power over trials, but there should be some block on arguments that connect policy issues that are not textually in the Constitution in some distant way to the Constitution. In any case, I think the most essential thing is to return to our root values, whatever theory we associate with them. Root values of legal objectivity, judicial restraint, democratic self-determination, and above all, majoritarianism. Thanks.
Thanks very much, Josh. Now we'll go to Professor Marc DeGirolami, who's the Carey Fields Professor of Law at St. John's and the co-director of their Center on Law and Religion.
Great. Well, thank you very much. I want to join my other panelists in thanking Professor McGinnis and Professor Barnett and the Federalist Society for inviting me to join this panel with such a rich and thoughtful variety of unhappiness on it. The discontent that I'll address concerns the relationship of originalism and politics, and I think it picks up on some of the things that Professor Merriam and Professor Kleinfeld have said. And by politics, I mean political morality, good governance, So in my view, originalists sometimes say two incompatible things. On the one hand, many originalists insist that originalism has no relationship to any politics, and certainly not to conservative politics. I have in mind social conservative politics especially, though I think the claim is actually general. Now, that claim sounds like the view associated, as Josh Kleinfeld has just said, with an older American legal conservatism. That is to say that law and politics are institutionally distinct. And in fact, originalism was attractive to early originalists, in part because it was thought to reflect that distinction, with implications, as Josh has said, for democratic politics, for the rule of law, for judicial deference, and all of that. But I think the claim today is actually quite different. The claim today is not about institutional deference to democratic majorities. It is instead about a conceptual separation between originalism and political morality. It sounds in legal positivism. So that's on the one hand. On the other hand, many other originalists connect originalism conceptually to distinctly political projects. Those projects are, and I think Jesse's right about this, generally classical, liberal, and libertarian. They are sometimes progressive, particularly when libertarian and progressive politics overlap. There are many examples, but I'm going to pick on John McGinnis just a little bit, who in a piece of just a few days ago said this, quote, "The appointment of Amy Coney Barrett has made the court more originalist and thus more classically liberal than it has been for over a century," close quote. The connection between originalism and libertarian politics exists too, and I think has been documented. In fact, I'm grateful to Jesse for some of his work in this respect. Now, I want to be clear that I'm not at all suggesting any kind of bad faith or talking out of both sides of one's mouth and so on. Still, I think it's fair to say that the discontented have noticed this kind of dual action within originalism. The denial that originalism has any conceptual connection to political morality, coupled with the explicit or tacit embrace of originalism to achieve classical liberal or libertarian or progressive ends. I think it's fair to say that part of the fragmentation that John McGinnis was mentioning within originalism concerns just this issue. That is, whether there is any conceptual relationship between originalism and political morality. Some are originalists for consequentialist political reasons. Others reject that view. And that fragmentation, I think, raises at least a couple of questions. If this division within originalism is real, what does one make of a single theory or movement or project that announces diametrically opposed assumptions and ends on such a crucial question? If this division within originalism is not real, then who is right? Either way, the discontented will have responses, but it would be helpful to know which one to pursue. Now, a footnote here revealing some of my own cards. Just as for law and religion, which is my own primary field, while there are certainly institutional distinctions between law and politics, there is no conceptual wall of separation between them. Witness as some small proof of the conceptual connection of political morality to interpretive method that virtually every originalist feels compelled to find an originalist justification for Brown, and most likely now feel compelled to find an originalist justification for United States versus Virginia. And I am aware of some who feel compelled to find an originalist justification for Obergefell versus Hodges. That number is surely increasing, and I suppose other connections will follow. The point is not to say that those decisions are right or wrong or anything of that nature. It is to say instead that there is a baseline political morality for every theory, and originalism is no exception. The discontent that I'm describing, born of this sort of dual action, has led some non-libertarian conservatives to repudiate originalism, basically concluding, look, originalism as presently practiced and defended is simply incapable of delivering legally and politically attractive outcomes, at least from that point of view, because it has no politics, or alternatively, because the politics that it has are not conservative. So being told that originalism has nothing to do with politics, that law and politics are absolutely separate enterprises, but also that the constitutional text embodies libertarian principles that can be divined in, for example, the word liberty in the 14th Amendment, these responses, I think, exacerbate the discontent. Now, speaking of principles, and in this way, I'll conclude now. I'm going to connect a little bit, I think, with what Josh said at the end of his comments. The primary methodological culprit for what many of the discontented see as a kind of sleight of hand played on them by the dual action that I've described is originalist tendency to speak in terms of abstract principle. Originalism's recurrence to high principle to discern the meaning of unclear text, to the detriment in some cases and the exclusion in others of concrete practices and traditions that have grown up around the text, has resulted in an originalism that often claims political neutrality, but that is instead densely political. I have written about how those who are discontented with this state of affairs would do well to concretize originalism. And here, I think my comments do overlap to some extent with Josh's, emphasizing the relevance of tradition and enduring practice to discerning textual meaning. I would offer the same argument to originalists who are aware of the discontent and interested in finding ways to mitigate it. Now, fortunately, there is a long tradition of traditionalism in constitutional interpretation that could be integrated or fused with originalism, at least originalism of some kinds, within some variations. And I think actually John McGinnis has recently written about this, some justices, Justice Alito is one, have already begun to develop this sort of approach. Fusion, I should also add, would be my own preferred and in its own old-fashioned way, conservative approach to this rift. I agree with what Josh said, that it would be decidedly unconservative to just sort of trash originalism and move on, especially in light of originalism's well-merited successes. Now, I don't claim that my approach or any approach really would be apolitical. There would be a conceptual relationship between my interpretive approach and political morality, even as I think an institutional separation could be maintained. But in my view, at least, that would not distinguish my approach from any other interpretive theory. Thank you very much.
Thanks very much, Professor DeGirolami. Now we'll go to Professor Mulligan, Professor Christina Mulligan, who's a Vice Dean and Professor at Brooklyn Law School. We look forward to your remarks.
Thank you, John, and thanks for this opportunity. So this panel is called Originalism and its Discontents. And while I am an originalist and don't count myself among the discontented, I do write about critiques of originalism, specifically critiques that involve originalism's relationship with race and gender. These critiques, of course, come from the left, and this panel is largely focused on critiques of originalism from conservatives and libertarians. And so while I want to touch on these critiques from the left, I also want to address the parallels between these critiques from the left and from the right. So many of us are familiar with the broad categories of critiques of originalism, that it yields outcomes that some people don't like, that its practitioners are too consciously or unconsciously biased to do originalism well, that originalism is too hard to do correctly, or that the white male dead founders just shouldn't control what we do today. A key insight about these critiques is to recognize that some criticisms of originalism are about the past and some are about the present. Sorry, one sec. Computer error. And some criticisms are about the present. The criticisms about the past are things that we can argue about the relevancy of, but not do so much about. And so surprisingly, for a history-focused practice, criticism of how originalism is done in the present becomes much more important to consider and to respond to with action. And so what are these present-day criticisms? From the left, there's the criticism that originalists and people associated with them, Republicans, conservatives, libertarians, don't really care about the rights and liberty of women and people of color. And so why trust originalists when they advocate for a philosophy that symbolizes and reinforces a sexist and racist past? And from the right, there's a parallel criticism that many prominent originalists seem unconcerned with traditional values and with protecting the interests of religious people, and that they're more concerned with protecting values such as autonomy and economic liberty and the right to live a peaceful life of one's choosing. So if these concerns are accurate, the relatively homogeneous population of originalists are more likely to, perhaps unintentionally, reinforce their own preferences and expectations when they interpret the Constitution and see what they expect given their own beliefs and experiences, rather than see what the framing or amendment ratifying era populations actually did believe and write. The interests of people of color and of women, or of the faithful and the traditional, will be given short shrift, not always because the Constitution does not protect them or advance their interests, but sometimes because originalist interpreters will not see what is actually there due to their own biases and limitations. In my article, Diverse Originalism, I argue that originalists can learn from these concerns involving different populations while still being completely faithful to originalist methods. As originalists acknowledge, there is always the risk that unintentional bias will interfere with our ability to identify the constraints and meanings of the Constitution. And so to combat that possibility, originalists should value an originalist practice in which those doing the interpretation come from a diverse variety of perspectives. It's important to cultivate a diverse population of originalist interpreters for its own sake. Randy brings a different perspective than Josh. And while neither is more likely to be right based on who they are or based on their gender or race or religion or political commitments, the fact that they will look at the same evidence with a different eye increases the likelihood that they will see different things and correct each other's unintentional mistakes. So the answer to the social conservative or traditionalist or religious person who does not see themselves represented in originalism is to say, come into the tent. Because their diversity of perspective is a tool of accurate interpretation, and to commit to looking at historical sources that espoused diverse views as well. And the answer is also for originalists today to be conscientious about applying originalism consistently across legal issues, regardless of whether the person whose interest is at stake in a particular case is white or black, atheist, or religious. The alternative to these suggestions, whether that alternative is articulated from the right or the left, is often to replace originalism with a governing philosophy more focused on substantive outcome. And there are many alternatives to originalism, and they're differently principled and differently bounded. But at least some of these alternatives offer what is primarily a theory of policy, less concerned with the structural bulwarks against abusive government that originalism offers. And we can mistakenly forget to worry about abusive power when it seems like the alternative comports with our own preferences. But that risk of abusive power remains, and we need to remember that any constitutional system should remain appealing when either your political allies or political enemies are in charge. The one particular alternative to originalism that I have in mind is Adrian Vermeule's description of common good constitutionalism. Vermeule appeals to rich traditions in thought when he references the common good, but we still can't escape from a question that should haunt us. Whose idea of the common good are we talking about? It mirrors another question you might ask in a different context. Whose idea of economic and social justice are we talking about? The question of what is the common good is a policy question. It is a moral question, but it's not a legal question. And to substitute originalism with common good constitutionalism is to substitute a system that strives for rule of law for one where governors can impose their particular vision of the good on others beyond the scope necessary to function together as members of a single polity. Political tides change, and common good constitutionalism will eventually become a mirror image of itself. I worry that to embrace it is to ensure that conservatives will soon be fighting against what Marc advocated as the abandonment of defensive crouch liberal constitutionalism. In his essay in The Atlantic, Vermeule wrote that in his view of the common good, quote, just authority can be exercised for the good of subjects, even against their own perceptions of what is best for them. And it's certainly true that sometimes we are wrong about what's good for us, but this formulation drives home that question of whose conception of the good will be served by the abandonment of originalism. This formulation rightly abandons the fiction that the common good really can be agreed upon by a single polity and admits that someone else may and maybe must choose it besides those who are governed. In that same essay, Vermeule also critiques the, quote, urban gentry liberals who so often place their satisfactions, financial and sexual, and the good of their class or social milieu above the common good. The coastal liberal's good is not Vermeule's good, and Ronald Dworkin's good is not Vermeule's good. But a constitution that can implement Vermeule's conception of the good can implement whatever conception of the good is held by those in power. And that's no foundation on which to build a government or society of people who struggle in good faith with each other about how best to live their lives. Now, I admit, originalism is not the only theory of constitutional law and constitutional interpretation that's capable of constraining the power of government appropriately. And it's imperfect, as all parchment barriers are, no matter how constructed the words are on the parchment. But before turning to an alternative, we should be pretty sure of what else we're inviting in with it.
Thank you very much, Professor Mulligan. Now to round us up and also to respond to some of these criticisms of originalism, we have Randy Barnett, the Carmack Waterhouse Professor of Legal Theory at Georgetown and the director of its Center for the Constitution. Professor Barnett.
Well, thank you, John, and thanks to all of the participants of this panel who have presented such thoughtful, careful, and succinct remarks. Unlike the others, I waited to hear what they had to say before I could prepare what I was going to say. And so mine may not be as coherent, as succinct as theirs are, because I'm kind of doing this on the fly. And I wish I had more time to address each and every one of the observations, the very thoughtful observations that have been made, but I'm not going to be able to do so. I'm going to have to focus on what I think are the core claims that were being offered. Also, I'm not going to say anything about Christina's excellent presentation because I largely agree with it, and it provides one kind of response to what I've heard. In fact, it's very much in the vein of the first thing I'm going to talk about. Before I get to that, I want to define what I think originalism is, because in discussions like this, the definition often gets lost, or at least we may not be talking about the same thing. So to my mind, originalism is a family of theories that are related to each other. They're not all the same as each other, as all family resemblances are not the same. But the family of theories is identified by its commitment to two key principles or concepts. The first is called the fixation thesis, and the second is the constraint principle. The fixation thesis is that the meaning of the text of the Constitution was fixed at the time it was enacted, that there was a meaning, and that meaning was fixed at the time it was enacted. Different originalists will disagree about exactly how it was fixed and what was fixed, but they agree that it was fixed. And of course, the time of enactment is going to vary from the time of the enactment of the original Constitution with the time of the enactment of the first 10 amendments and the time of the enactment of the Reconstruction Amendments. Those meetings were fixed at different times, but that's when they were fixed. The second principle of originalism is this constraint principle, and that is a normative. The first principle, I should say, is a descriptive principle. It just basically says, as a matter of language and the matter of meaning, that's what the meaning is of the text of the Constitution. The very same way, if we wanted to know what the meaning of the Confederate Constitution was, we would look at what the meaning was fixed at the time the Confederate Constitution was enacted. That's simply a description of what it meant, what it means, what it meant. The second claim is normative, and that is that the fixed meaning of the Constitution ought to constrain contemporary actors, contemporary constitutional actors, be they judges or legislators or the executive branch officials, that there's some constraint associated with that fixation, and those actors can't unilaterally or on their own change that meaning to something they prefer better. So in other words, this can all be summarized that the meaning of the Constitution, which is fixed, the fixed meaning of the Constitution should remain the same until it's properly changed by amendment. That's originalism. Now you'll notice that from this definition that none of the three more critical speakers of originalism today really took issue with any of those principles. There are implications of what they said that would maybe require them to take issue with those principles. Maybe some implications of what Josh said would require him to take issue with those principles, and he'd have to wrestle with those principles and see to what extent he wishes to abandon them. Although there are inclinations or inklings in what he said that suggest he does not want to abandon them. But if he does not want to abandon them, then he is operating within originalism, not outside originalism. And there's a lot of diversity within originalism, as the panelists have already noted. So that's my first observation. That's what originalism is. It is a tent. It is a family. It is not a single thing, but it has some core commonalities. And it's within those commonalities that originalists debate, and they are distinct from non-originalists who reject one or both, either the fixation thesis, they say the meaning is not fixed, the meaning evolves over time, or two, whatever meaning is in the text of the written Constitution may or may not be binding. It is a factor to be taken into account, among other factors to be taken into account. This is what David Strauss's position is in his book, The Living Constitution. There's a difference between non-originalists and originalists. And I'd be somewhat surprised if the critics of originalism on this panel actually reject originalism at the end of the day. Maybe they don't. Now, let me just talk specifically a little bit about Jesse, Josh, and Marc's remarks, because I think each one of them brings to the fore elements of disagreement within the originalist movement, within the conservative legal movement, I should say, that are worth paying attention to. And as I say, worth more serious response than I'm capable of doing on the fly or given the limited time I have today, but I just want to highlight them. The first one I'll talk about is Jesse, and I think Christina's remarks address this as well, and that is the difference between means and ends. Jesse's principal point was, why should conservatives as a political movement judge their success or failure of the conservatism on the basis of the success or failure of originalism, when originalism may or may not provide the conservative ends that conservatives wish to accomplish? It's actually a pretty good question. But the question is answered by the distinction between means and ends. And that is, there are different kinds of conservatism, just as there are different kinds of originalists. And conservatives who are actually within the classical liberal tradition, which are most of what we would call mainstream conservatives today, not all, but most, believe in a distinction between means and ends. And they believe the means, and as classical liberals have long believed, that the means are essential to obtaining, adhering to good means is essential to obtaining good ends. And even where you think you might be able to attain ends by disregarding the means and just jumping to the end, you're likely to be wrong about that. In fact, you're almost certainly going to be wrong about that. That you must stick with appropriate means, and the most obvious category of means is known as the rule of law. You must stick with the means that we would associate, let's say, with the rule of law in order to achieve good ends overall and in the long run, as opposed to violating the rule of law because the rule of law is not giving you the results that you're looking for. This is a core principle of classical liberalism. And I don't mean by this libertarianism. I mean classical liberalism, of which people like Adrian Vermeule, for example, are highly critical. They reject classical liberalism, just as the left has rejected classical liberalism, and liberalism is their principal opponent. But most modern conservatives, like most modern libertarians, are part of the classical liberal tradition. And I want to highlight that tradition focuses important attention on the distinction between means and ends. The Constitution is only a means to an end. And that's all that it is. It is not an end in itself. But sticking to the Constitution, if it's a good enough Constitution, substantively good enough Constitution, which starts to bring me to Marc's point, if it's a good enough Constitution, will likely lead to better ends than abandoning the rule of law as associated with this particular written Constitution and just skipping to what we might call result-oriented jurisprudence, which is what many of the discontents with originalism seem to be favoring. So let me now then move to Marc's point, because I think it's closely related to what I've just said, and that is the relationship of originalism to political morality. He says that originalists deny the connection between originalism and political morality. I think that's not so. I don't think that's an accurate description of originalists, and almost any originalist. I think people, when they distinguish, I think what's true about what Marc says, or what he may actually be detecting, is a distinction between the means and the ends. That is, originalists do focus a lot of attention on the means. And they argue that sticking to a written constitution, as long as the written constitution says enough of the right things and does enough of the right things, sticking to a written constitution is going to lead to better ends from the perspective of political morality than abandoning the written constitution and just empowering governmental authorities, whether they be majorities in legislatures or judges or presidents, to simply adopt the ends that we know are to be the correct ones according to our fundamental principles of political morality. I, for one, support the Constitution. I support originalism and the Constitution because of my commitment, my pre-existing commitment to natural rights, the very same conception of natural rights that the founders were committed to and that the authors of the Reconstruction Amendments were deeply, deeply committed to. But I do not believe that empowers judges or especially judges to simply formulate what natural rights are and enforce their conception of natural rights. I strongly disagree with that, and my writings have always disagreed with that. And my forthcoming book from Harvard Press on the original meaning of the 14th Amendment will make that clear. It will also make clear that where judges protect fundamental rights under the rubric of the Privileges or Immunities Clause, they should look to rights that have been enumerated in the Constitution, in the Civil Rights Act of 1866, as well as in state constitutional law, as well as in state constitutional law, positive law of state constitutions, and that the only unenumerated rights, other than those that should be recognized, are those that are deeply rooted in the nation's tradition and history, which should sound familiar and congenial to Marc's approach to tradition and history. In other words, in my view of the 14th Amendment and the Privileged Immunities Clause, there's an important role to be played by history and tradition. And now let me turn to, but I will say one more thing, is only political morality is going to justify all of this. Because remember, the second tenet of originalism is an ought, not an is. And that ought is that the original meaning of the Constitution ought to constrain contemporary constitutional decision makers. That's going to be a normative question rooted in a political morality. The fact that there are competing political moralities that yield the same answer only reveals that that's the right answer. That is, there's an overlapping consensus amongst different normative approaches as to why this is a good idea. And I don't think that's a bad thing. I think that's a good thing. It's a sign that this is actually the right direction to go if multiple moral arguments lead in the same direction. Okay, finally, let me talk a bit about Josh and Josh's point. Josh, I welcome you into the originalism debate, but I'm going to tell you that it's not, you are a very, very insightful and powerful theorist, legal theorist. You do legal theory, and you do it at a very high and sophisticated level. But let me just inform you, because many people outside of constitutional law are not as aware of this. Constitutional law is also a matter of legal theory, and it's not all that easy to do. So as I welcome you into the realm of constitutional theory, let me advise you, it's a difficult terrain to navigate, and you need to be able to do your work, and you haven't done it yet. And what you've basically done is you have articulated one particular theoretical position within this intellectual space, one that has been heavily criticized. And you're more than welcome to defend that position, but you're going to have to articulate it, and then you're going to have to understand the critiques that have been made against it, and then you're going to have to respond to those critiques effectively. You just haven't done it yet. I have no doubt whatsoever you can do it, because I know what a brilliant mind you have, but you haven't done it yet. And so I look forward to your future contributions to the theory of interpretation, which includes the theory of originalism. So let me just talk a little bit about the point that you do make, which is one that is actually very familiar within originalist debate, and that is the difference between originalism as a theory of interpretation and judicial role, how judges should act towards that original meaning. Because you'll notice when I identified how I define the family of originalist theories, I defined it in terms of ascertaining the original meaning of the text of the Constitution. What does the meaning, what does the Constitution mean? And when, Josh, you talk about crude textualism or some version of simple textualism, you are also making a claim of meaning that is not inhospitable to this. You are actually within the framework of originalism when you make that textualist argument. And then the next question is, well, what do you do when, in your terms, the Constitution is silent? Who gets to decide when you say the Constitution is silent? Well, first of all, I dispute that the Constitution is as silent about the matters as you think they are. I think if you start examining the original meaning of clauses such as the Privileges or Immunities Clause, the Due Process of Law clauses in the 5th and 14th Amendments, you're going to find that the Constitution speaks to things. And just because it speaks to things in general terms doesn't mean it's silent. It just means you're going to have to get specific within those general terms that the Constitution speaks in. But that's a debate we have within originalism. And what is the original meaning of the due process of law? What is the original meaning of the privileges or immunities of citizens of the United States? That is an internal dispute amongst originalists about which originalist scholars disagree. But I will guess I'm going to, but the question of what judges should do about that meaning, in my view, is a separate matter. Now, some originalists think, no, that's not true. That in fact, how judges should behave is also a matter of original meaning. It can be built into, for example, the concept of the judicial power, let's say. That's another internal debate we can have, and we should have, and we continue to have. So welcome to that debate. Or as Bruce Willis said in Die Hard, welcome to the party. It's such a party going on. And speaking of parties going on, let me just close by talking about, in some sense, the elephant in the room that has emerged a couple times in a couple of different comments by, I think, all speakers, and that is the libertarians in the room. That really what has happened here, and people have been very polite on this panel, so they haven't said a lot of what gets said outside, out of doors, so to speak. And that is that really the libertarians have taken over the originalist movement, and to the detriment of the conservatives who used to run things around here. That's to our detriment. And witness, for example, I mean, Josh has the example of the Affordable Care Act challenge, which I just have to tell you was not an originalist challenge at all. It was based, and as the guy who kind of has something to do with the idea, it's based entirely on existing constitutional doctrine. It wasn't based on original meaning from beginning to end. It wasn't. It may have been influenced by the fact that existing doctrine has departed a lot from original meaning, but the arguments were not originalist at all, or we wouldn't have gotten 4 votes. And we wouldn't have gotten the original 5 votes we had before we lost one of those votes after the conference vote. Anyway, but what about the libertarians in the room? So let me just say this about that, and I'm happy to talk more about this. Number one, I'm a libertarian. I don't think the Constitution is a perfectly libertarian document. I don't think the fixed meaning of the Constitution is perfectly libertarian. I do think the fixed meaning of the Constitution is more libertarian than the living Constitution that progressives have given us over the last 60 years. So moving towards original meaning is going to be moving what you might call in a somewhat libertarian direction, because the original meaning is more, quote, libertarian or classical liberal than the living constitutionalist progressives have given us. So that's true. But it is not a perfectly libertarian constitution. It empowers much government action that libertarians would disagree with on a policy level, that provides much room, for example, if you're not even talking about restricting liberty, but you're just talking about taxing and spending, to tax and to spend a lot of money on social programs that may or may not be a good idea from a libertarian perspective. There's just a lot in the Constitution that in the government the Constitution empowers that allows for both conservative and progressive policies to be pursued by Democratic majorities in legislatures, exercising maybe primarily their spending power, but also their powers of regulation. So let me just say that. It's not a perfectly libertarian Constitution. And let me finally say that the judges who have been appointed by the Trump administration, who are now self-consciously originalist in ways that judges appointed by the Bush administration and Reagan administration were not necessarily, those judges are not libertarians by and large. And those judges, the philosophies that those judges have manifested both in their rulings as well as in their public statements have not been my views. They have not adopted Randy Barnett, the bad libertarian influence on originalist views. They, by and large, are mainstream conservative Republicans, and they have largely adopted the views of judicial restraint that are favored by Josh, and I take it also probably by Marc and Jesse, but I will, maybe not. But they are generally restrained people. Those libertarians within this movement have not won the argument about the original meaning of the due process of law, for example. We have not won that argument. And if I were in a room of judges who were members of the Federalist Society, they would argue with me about that. They would not agree with me about that. So by and large, the judges that have been chosen to be on the bench are more or less restrained people. But the problem here is, of course, the more or less part, because no restrained person is a perfectly restrained person. Witness the stance of the judiciary towards the severe restrictions on liberty we've all been living under COVID. Originalist judges, with few exceptions, have not stepped up to question the exercise of the police power as a violation of the due process of law for many, many reasons that it might be. At any rate, let me just suggest that libertarians, though they may be very vocal and successful within the intellectual movement called originalism, have not yet prevailed in the political movement that Jesse talks about, which leads to those judges who get selected to be put on the federal judiciary, even those judges who call themselves, quite rightly call themselves, and I believe sincerely call themselves, originalists.
Thank you very much, Professor Barnett. I think what we'll do now, since I want to leave ample time for questions, is to give very briefly any panelist who would like to 2 minutes, and I'm going to enforce this pretty strictly, to respond to Randy's critiques of your critique, and then we'll go to questions. So, Professor Kleinfeld, I think you might begin.
Randy, I find a lot of your remarks quite compelling, including the one that constitutional theory is a dense and difficult domain that I have not, I've only taken a sort of first step into. This panel is indeed the first step for me. So I'm articulating some intuitions, and I have a lot of unanswered questions. I want to respond to you by sounding one of those intuitions and unanswered questions. So here it is. I think I can accept the fixation thesis. And maybe even the constraint principle, although I have more misgivings about the constraint principle. It seems to me that the Constitution is above all a charter of self-government, and what's fixed into place is sufficiently a matter of majoritarian self-government that it can only even conceptually allow for very limited carve-outs for rights not subject or structures not subject to democratic control, because it is above all a charter of self-government. So that's my first rejoinder. Do you agree with me that the Constitution's commitment to majoritarian self-government is so deep that there's very limited room for the sort of libertarian carve-outs? Here's my other rejoinder. What troubles me about constitutional theory as a field is that the legal community that comprises constitutional theorists, a legal community that includes the academy and a number of judges and also includes leading appellate lawyers, are just ingenious in their ability to connect virtually any policy issue under the sun to some issue of the Constitution and thereby make it subject to judicial power. So which one of your two principles, fixation or constraint or some third principle, should give us the ability to say the Constitution doesn't talk about that?
Oh, thank you. Professor Merriam.
Yeah, so I'll just comment on, I guess, two of the criticisms or points that Randy made about means versus ends and the rule of law in regard to classical liberalism. So I agree entirely in terms of the ideal legal system would have that sort of distinction between means and ends. And that is a central part of classical liberalism and the rule of law. And originalism can potentially, and perhaps to some extent does in practice, contribute to these two. But I do think the way that originalism has been operating for the past couple of decades, and I do place that emphasis in the last couple of decades because it's a relatively recent shift, does not have the demarcation between means and ends that has been suggested. The fact that we have a canon in constitutional discourse whereby after each major progressive victory, conservatives and originalists must try to show how originalism can be defended to justify those outcomes, suggests that that distinction between means and ends is not nearly as sharp as suggested. And you could see this in many different instances. Perhaps most illustrative of this phenomenon is Calabresi's article after Obergefell. No one, 20 years ago, 15 years ago, even 10 years ago would think that same-sex marriage is part of the 14th Amendment. But right after the Supreme Court found so, in non-originalist ways, we have all of a sudden literature saying that it could be also discovered through originalist means. That to me does not suggest that this is a field of inquiry or mode of interpretation where means and ends are entirely or conceptually distinct from one another. I do not want to have a conflation of means and ends. I'm worried that that is exactly what we do have the way that originalism is currently practiced. I also don't want a form of legal interpretation that is entirely tethered to politics. But the fact that the way that we do originalism now rests on a presumption of whether it's judicial restraint or libertarianism means that there is not that distinction between law and politics that we all would like. And if originalism is merely a family of theories, which I think it actually is, I don't think that it can achieve the goals that we would like it to. And my criticism is really not targeted at any of you, but those who study legal conservatism and are neglectful of the fact that there are a family of theories, many of which are quite accommodating and increasingly accommodating of a progressive agenda.
Professor DeGirolami, please.
Thank you, Professor McGinnis. So I'm actually deeply grateful for Professor Barnett's comments, and agree with a number of them. I agree that there's a distinction between means and ends, although that's all you have to do is, McCulloch is famously cloudy on that very question, exactly what is a means and what is an end. And I would also say that ideals like the rule of law, while they certainly relate to means, there's nothing particularly necessarily classical liberal about the rule of law. The rule of law is an ideal that has been talked about by natural law theorists all the way back to Cicero. So these sort of proceduralist ideals that we have imported today, they don't necessarily have 18th, 17th, or 18th century roots. In fact, they're quite a bit older than that. And so I welcome a chance to, how to put it, incorporate or fuse some of those older traditions, if in fact they are the kind of progenitors of some of the means-oriented traditions that we have today. And I think there's a fair argument that there is, into the current discourse. Now, I want to say one more thing, and then I think, one answer that Randy puts to me, and I think it's a good one, is to say, look, at least part of the libertarianness of the legal conservative movement is explained by the fact that those folks have invested a lot of resources in defending the actual Constitution, and the actual Constitution is only as conservative as it is, right? The document explicitly protects things like free exercise and contractual obligations and property rights. And maybe it's just true that the founders had a kind of thumb on the scale against invasions of a kind of libertarian view of the common law. But to that, I'd say, well, that might be right, but the Constitution maybe isn't so libertarian as some make it out to be. It allows for things like high taxes. It allows for embargoes. It allows for wars. It allows for onerous militia and jury service. It allows, most fundamentally, for an extremely broad range of state legislation, maybe including state establishments of religion, if Justice Thomas is right. So I appreciate Randy raising the issue of substantive due process and due process more broadly. That those are those are possibly more socially conservative features of the original Constitution than some of these other features that we've been talking about. And so maybe some of the discontent is, gee, I just wish that those features of the Constitution had gotten a little bit more airtime, that they've had a little bit more play than they've had so far. And maybe that's coming. And if so, perhaps that would be an occasion to sort of fuse the kinds of things that I'm talking about with the sorts of things that you're talking about. Thanks very much.
Thanks, Professor DeGirolami. Please go on to Professor Mulligan.
You know, Marc's comments remind me of the importance of having a diversity of views present when we're doing constitutional interpretation, because it is, of course, very possible that things go unseen or unnoticed that are there within the Constitution because of who's doing the interpreting. But that's not an argument against originalism or particularly any other theory of interpretation. So there's two themes that I think are really important to walk away from this discussion with. One of them is this contrast between rule of law and results-oriented reasoning or constitutionalism. And many of the discontentments with originalism can be fit within the originalist discussion: how much restraint, how much deference, et cetera. And others are explicitly external critiques, as in saying we don't want constraint or fixation, and we should do something different. And when we discuss this, and there's been differences on this panel about this, we need to be very clear about what kind of disagreement we're having, because it raises very different kinds of issues politically and morally. The second note, which is beating a drum that's long been beaten, is that the reality that people have biases or pre-commitments that funnel into their interpretation of the law, whether it's through originalism or some other theory that has constraint or an objective outcome, doesn't necessarily mean that the theory is wrong, or that we can't achieve more rule of law oriented reasoning or objectivity. Because this is just the human condition, what it means is that we need to create better structures to prevent losing that objectivity, that reasonableness, the ability to be governed by rules and laws instead of by preference. You know, I'm reminded of one of my favorite tweet storms by Stephen Sachs many years ago, where he says, listen, we all know that sometimes professors prefer, like certain students more than others, and yet we build systems where we grade exams anonymously in order to prevent that, rather than saying, listen, people are going to be biased no matter what, so we're just going to have a leaderboard of who I like this semester on the wall at all times. The fact that bias or that preference influences humans is just a necessary part of being a human being, not something that is so unavoidable that we should just abandon rules, laws, and constraints in favor of the war of all against all and a power struggle.
Well, thank you very much. I hope we might go to questions now, and then we'll work people in as the questioner suggests. So first, let me say that you should, if you want to ask a question, you should raise your Zoom hand, and or if you're on the phone, you should press *9. And so the first question comes from Christopher Green.
Okay, you can hear me?
We can.
Oh, good, good. So I'm curious what everyone thinks about the fact that it really doesn't seem that difficult sometimes to get people to buy into the constraint principle. So for instance, Adrian Vermeule, who has said all kinds of super nasty things about originalism, he quite enthusiastically endorsed Euclid versus Ambler Realty, which says the meaning of the Constitution doesn't change, although the applications can. One lesson you could draw from that would be, well, we don't just need originalist judges. We need judges who are going to be good at finding the relevant facts. We need judges who are going to be appropriately humble about their ability to find the relevant facts and defer to legislatures or the elected branches when they can't. So maybe part of the problem with the current constitutional discourse is that we think the issue of originalism as such is more important than it is. And of course, I think it's pretty important, but I don't think it's the be all and end all.
So perhaps Professor Merriam, we begin with that. I think those comments go somewhat to your remarks.
Yeah, so I largely agree that originalism probably is not as important as we make it out to be, given the way that it has changed over time. So I imagine that in the 1970s and 80s, when it was very confining, under the way that Bork or Berger or even Scalia thought about originalism, then I do think it was very important to identify as an originalist because it was so exclusionary of so many different ways of looking at the Constitution. But now that it has become a much more extended family that can embrace widely divergent perspectives, I do think that the importance of the theory, even though it's become more ascendant, and actually because it's become more ascendant, is just less of a distinguishing feature. Like I started my talk out by saying, if I were a judge or I were a law professor as part of my job, I would say I'm an originalist. And if you ask me right now, if I were forced to identify myself, I'd say I'm an originalist. But that does not resolve a lot of the disputes. And I don't think that's a problem. I mean, I do think that it is helpful to say, all right, we all agree that the constitutional language fixes meaning and judges ought to be constrained by that meaning. But obviously, there are going to be very big disagreements nevertheless. And my concern, of course, as someone who writes about judicial politics and social movements is, well, that's all good, but then a social movement that is pursuing a particular ideological agenda in accord with how it thinks the Constitution should be interpreted based on the founding should probably spend less time on the originalism project and more time on what that constitutional order looks like, as apart from merely the nomenclature of originalism.
Does any one other person want to contribute? We want to, if I get all the questions in, but please, someone else might want to have something to say about this. Okay, if not, we'll go on to Professor to Leotis.
Hi, everybody. Delighted to see you. I guess I have an observation and then a question. The observation is that I was very interested in the focus of Jesse's remarks because I think it takes aim at this somewhat excessively triumphalist for conservatives narrative that has been put forward, largely by people on the left, actually. I don't think you would find a lot of conservatives claiming that, that legal conservatism has triumphed. And on the other hand, there's not that much incentive, I suppose, for legal conservatives to say, well, no, not really, it hasn't triumphed. So, and then there was one particular manifestation of that, I think, in Josh's remarks, which also, I think, are sort of accepting, understandably, but I think incorrectly, a narrative about the Affordable Care Act litigation that, again, was kind of put forward significantly on the left, and then that there's not that much incentive to take issue with, among conservatives. And so I think both of these popular, these efforts by, in some ways, theorists on the left are creating some confusion. The particular manifestation I have in mind is the notion that this theory sprang wholesale from the head of Randy Barnett after the Affordable Care Act was adopted in Congress, and the particular thing I just want to flag on that, there's a lot of evidence to the contrary on that, but the particular thing I want to flag is that there was a Congressional Research Service report at the time that Congress was looking at it, and very early at the time Congress was looking at it, saying, wait a sec, this individual mandate is going to be problematic under current Supreme Court doctrine, as Randy points out. And the CRS is nothing if not, very conventional in its legal thinking, as opposed to originalist in its legal thinking. Now, it may be that the incentive, not only the incentive to push the theory, but also in the background, there may have been an originalist view about the Commerce Clause that was informing why the doubts might be right rather than wrong. But I just wanted to sort of flag both of those points, which I think are related. And then I wanted to ask a question, which is about stare decisis, and which I think is a possible, at least substantial, alternative explanation for some of the ways in which the conservative legal movement has not been as successful as some might like it to be in overturning existing precedents, and what the role of stare decisis is in originalist theory.
Okay, Professor Barnett wants to.
I just want to underscore something Lee said, that in my Heritage Foundation legal policy memorandum that was in November of 2009, which was the start of the theory, or that was the first enunciation of the theory that came to be the challenge. That report leads with an epigraph from the Congressional Research Service report that Lee's talking about. We relied on that report, and I elevated the importance of that report to an epigraph quote that's at the highlight or the beginning of our legal policy memorandum for Heritage.
Can I say something about this as well? I don't think the problems I identified, the problem of just too much judicial power and too little room for majoritarian self-government, are unique to originalism. In fact, they're probably less pronounced with originalism than with many traditional constitutional methods. What bothers me is that originalism started out, or at least some of its early impulses, were as a solution to that problem, and I don't think it has achieved its promise. I don't think it is now, its leading academic champions, including Randy and John and Steve Calabresi and others, and many of its leading judicial champions are no longer interested in that original aspiration. So here's what I mean. When you look at I didn't mean to imply that the Affordable Care Act was grounded in originalist thinking, but what struck me was the Constitution should just allow it. And I know that's controversial. I know that Randy doesn't think so, and I know Lee doesn't think so, but it seems to me that what we've got is a structure of government where it sort of doesn't matter. It could be pandemic response, it could be Obamacare, it could be some future climate change statute, it could be the creation of an agency, whatever it is. That community of constitutional theorists Randy earlier referred to, with their dense and genius theorizing, will come up with some way to relate it to the Constitution, and the self-reflexive character of constitutional review, where someone makes a constitutional claim and it's the judiciary's role to decide whether that constitutional claim has any merit, necessarily puts the judiciary in charge of all other aspects of democratic self-government. And what I'm looking for is a theory that will say the Constitution doesn't speak to that. This isn't any of judges' business. This belongs to the democracy. Originalism was supposed to be that theory. And I think it's failed of its promise, and it's failed of its promise because many of the people who most believe in it don't want to see a sort of judicial minimalism and a majoritarian maximization. They want to see very, very aggressive judicial review, and that is precisely what Steve Calabresi says in that article against Thayer. He says,
very briefly, Professor DeGirolami wants to get in. Then we still have 3 people on the queue. I'm going to ask them all to ask their questions, and then we'll have a final summing up.
Just quickly on the matter that Lee mentioned with respect to stare decisis. and stare decisis relationship, or its problem, quote unquote, problem for originalism. I've actually written recently about this, and I think that if one takes, it's sometimes said that the stare decisis presents a problem because there are all of these precedents that are not consistent with original meaning. How do originalists handle that? What's the program, and so on? And I know that this is a very prominent subject for originalists. My own view is, if one takes endurance and stability in the law to be one of the primary virtues of stare decisis, as I do, then that seems to me yet another way in which, again, legal endurance, practices that have lasted a long time, could well be fused within an originalist methodology. So there again, we have another possible way in to, shall we say, adapt originalism to some of these difficulties or problems or dissenting views that seem to be besetting it.
So we have 3 people in the queue. I'm going to ask them to ask their questions, and then maybe for people then to sum up and maybe answer some of these questions. The first actually comes in on the chat, so I'll read it. And this is to Professor Merriam, because every case, this is from Mr. Hernick, because every case is fought on the terrain the plaintiff chooses, has originalism really evolved, as you say, or have judicial activist litigators simply chosen more activist terrain, and conservatives have had to respond accordingly? So we'll then go to Lyle Weinberger, your question.
To answer very quickly, it's a very good question, and I think to understand.
Excuse me, Professor Merriam. We're first of all going to go to Lyle Weinberger, then we're going to have everyone is going to respond to have a few minutes to sum up and respond to the questions simultaneously. Thank you.
Great, thank you. Thanks for this great discussion. I want to ask a question about the divide over liberalism and non-liberalism that seems to also be in the background of some of the recent conversations, especially Adrian Vermeule has put this at the centerpiece. And Randy and Christina both referenced some things that emphasize the classical liberal nature of the Constitution. And I wanted to ask a question, I'm not sure if the panelists agree on this, which is, can one be an originalist without being a liberal? Everyone agrees that one can be a liberal in political theory, classical liberal, Rawlsian liberal, various forms of liberalism. One could be a liberal of some sort without being an originalist. I wonder if you think that one could be an originalist without being a liberal, and if that is something that's kind of driving some of the dissent from people like Vermeule. Thanks.
And then the final question is Laura Jenkins. Laura Jenkins?
Yeah. Can you hear me?
Yes.
Okay, thanks. Sorry for that. So my question is for Joshua Kleinfeld. And I very much share your concern with judicializing many issues and saying that the Constitution speaks on this issue. But my concern is that your view of the Constitution might be so narrow that it ends up pushing against constitutionalizing issues. And my concern here is that the Constitution has a rich life, not only inside the courts, but outside them as well. And my concern is that your view of originalism and constitutionalism might leave no role for the Constitution in general politics. And so my question is, how do you answer that? How do you, under this sort of majoritarian originalism, what role does the Constitution play in politics? Does it have any role at all? Thank you.
So we only have, I've been told by the organizers, 3 minutes, and so I'll have to make a sharp end at that. But we do have specific questions to Professor Merriam and Professor Kleinfeld. So let's begin with you and then see if any others have some opportunity, please.
With me or with Jesse?
With Professor Merriam.
Thank you. I'll answer very quickly. I think to understand how originalism and legal conservatism have shifted together, it's important to both look at originalism as a theory, which to answer the question has actually changed. So you can look at the way that the theory is conceived, the interpretation construction distinction, also known as new originalism, the move away from intention toward public meaning. There are a lot of shifts in the theory itself. But I do think that a lot of the shifts within legal conservatism can be traced to the organizations and activists that have been bringing claims. And a lot of the changes that we've been discussing with regard to originalism and the privileges or immunities clause, they actually began with non-originalist authors, or they weren't necessarily initiated by them. But if you read some of the early literature from Clint Bollock in 1989 was talking about shaping a legal conservative movement that was more libertarian in nature around an activist judiciary enforcing the 14th Amendment. And for him, that would mean either the due process clause or the privileges or immunities clause. And that wasn't necessarily originalist, but it took on an originalist significance when academics and theorists later took it on.
Thank you. 1 minute from Professor Kleinfeld, and I like 1 minute from Professor Barnett on liberalism, and can you be a conservative and originalist? Thanks.
I have to answer this really quickly. I'll just say that I think public discourse, this is Laura's question, I think public discourse is better than lawyerly discourse when it comes to balancing the majoritarian and the rights protecting elements of the Constitution. Here's what I mean. I think a lot of people in the public are open to the idea that, hey, the Constitution doesn't say anything about sex. We should stop having judges tell us what we can do and can't do with our sex life. Constitution doesn't say anything about healthcare. Constitution doesn't say anything about, those arguments fly with public members of the public. They do not fly with in the refined culture of legal theorists, and that is the problem. The problem is with the lawyers, not with the public.
Thank you. Can you be a non-liberal and an originalist, Randy Barnett?
You can be a non-liberal and an originalist if you think that the Constitution is law, that the meaning of the Constitution was fixed, and that constitutional actors should presumptively follow the law that is fixed in the written Constitution. Regardless of what your politics are, if you believe those things, then you can be an originalist. If you don't believe those things, then you are not an originalist.
Well, on that note, thanks to the panelists. I think it's a very lively discussion. Thanks so much. And thanks to the Federalist Society for hosting it. And let me say that the next panel will begin at 1 o'clock, and that will be a works in progress panel. And there you will need to register for that panel because it will not be live streamed. But 1 o'clock Eastern for the next panel. Thanks very much.